Good afternoon, everybody. This is Alex Barthet with the Barthet Construction Law Firm. Today we have actually our last Zoom Miami Construction Forum meeting. The next meeting we'll talk about at the end of the presentation will be in September, and it'll be live. I'll give you the details at the end. Today we're going to talk about the top 10 mistakes to avoid in your construction contract. We're going to go through 10 very specific items. I'm going to go through very specific contract provisions of what you should include and exclude. We'll answer all the questions at the end. You can submit the questions through the Q&A button in Zoom. And with that, we'll go ahead and get started. By the way, you don't need to take any notes because within a few days after today's presentation, Narcy in my office will send everyone the PowerPoint presentation as well as a link to the video if you want to watch it again or go back over any of the slides. So let's get right into it. So number one of the 10 items that we see clients make mistakes on is not reading the contract. I know this sounds tremendously obvious, but you would be surprised at the number of clients that come to us and say things like, it's too long, it's too complicated, I don't understand it, I can't make sense of it. And all of that may be true, but know that you need to take time to read it because all of the things that are in that contract could come back later to bite you. The contract means nothing when everything is going well. When things are not going so well, that's when people dust off the contract and they start holding you accountable for the things that are in the contract that you may not even know about. What we also see clients do is they look at the first few pages that may have the completion date, the contract price, relevant information about the project, the contractor, owner, and then they skip right to the exhibit, which may have a scope of work. And they spend all their time there talking, reviewing the scope of work. What they skip over is the 1, 2, 5, 50 pages of legal terms. And they don't bother reading them or changing them. So if something goes wrong, all of those terms are going to be used against you later. That's why you need to understand what they say and more importantly, what they mean and how they work. Always consider getting professional legal help when you have a contract, especially a contract that creates a lot of exposure for you. Maybe you have a long-standing relationship with a owner or contractor and therefore you're not so concerned, but maybe when you have a new relationship, you want to have that contract reviewed. Or maybe most of your contracts are in a certain price range. Now you have a new one that's much more significant, and maybe that's the time to get help with a contract review. The second mistake we see clients make is thinking that they cannot make changes to the contract. This is a mistake. You can make changes to almost every contract that is given to you. We find that almost every contract is negotiable. And under the theory that you don't get something if you don't ask for it, if you don't ask for those changes, they're not going to make them for you. Now, we often hear or see, we often hear from our clients, well, the owner, the contractor said that they won't accept any changes. Sometimes we even see in the contract itself words like in bold, all caps right at the top of the document, it says, no changes can be made or the contract is void. Again, everything is negotiable and you should be willing to make those changes. The way we typically do it is propose an addendum to the contract, an additional document that doesn't modify the actual terms in the contract. So we don't redline it or mark through it. It's a separate document that references the contract, that they're executed at the same time, and it supersedes, it stands in front of the terms and conditions of the contract. We're going to talk a little bit more about how to make that addendum and what to include or exclude. That comes a little later. Know that we see clients get between 10% and 30% of their proposed changes made. So it's always critical that you include some terms in your proposal that you're willing to give up, meaning you may decide that there's these 5 things that are really important to me. I would suggest to you that you don't go into this negotiation with just those 5 items. I would suggest that you go in with 15, 20 items so that you can give up on many of them and really focus in on those 5 changes. We find that if in the course of your negotiation, you're only negotiating from the terms that are most important, meaning in my example, those 5 terms, you're not likely going to get them. Now, you may not get them anyways, but you have a better chance of getting some of the most important terms to you if you have terms in the contract that you're willing to give up. The third mistake we see clients make is not getting the agreement in writing, whatever the agreement is. So ideally, the agreement, all agreements should be in writing. And the reason is, or I should say, all the terms, assumptions, exceptions must be in the agreement, or they don't exist. So if you have an understanding with the owner or the contractor that your price only includes excavation down to 2 feet, as an example, then that has to be in the agreement, because if there's a vague point in the agreement without that, in my example, 2 feet specific limitation, that can come back later as a something where the contractor or the owner says, well, I never agreed to that. And that's what we see. We see that the inclusion or the ability to have the written agreement avoids convenient memories. People saying, well, I never agreed to that. I don't remember that. Show me where it says that in the agreement. So if you have exclusions, assumptions, limitations, in addition to all of the other terms and conditions we'll talk about, it is absolutely critical that those show up in the contract. We have a client who's been in business for many, many years, and they have a long list of exclusions that they carry in every one of their contracts. And when asked about how they came up with those exclusions, their answer was that we made a mistake, something went wrong on a job, and because of that, we went and added it to our list of exclusions. So every one of the 20-some items that are their terms and conditions, they have a story. Well, that was the so-and-so job where we did this and the contractor did this, and this is what went wrong. So we made sure to add a provision so that that wouldn't happen again. So if you take a few minutes and stop and think of the things that you do, and more importantly, the things that you don't do, and you include those in your contract as terms, conditions, exclusions, assumptions, whatever you want to call them, it'll go a long way at avoiding disputes in the future. Remember, they may not agree, but at least you can put it on the table in advance that this is my expectation of what I'm going to do and not do. And the other side will have to come back and tell you, no, we don't agree to that because our expectation is different. You're better off having that conversation before you start your work rather than after. Now, we get this question a lot. Well, what about my estimate or my bid or my quote? Are those contracts? And the answer is absolutely. Any agreement that you have that's ideally executed by both parties in advance of the bulk of the work becomes your contract. So what's important? It's important that it be in writing, and that if that's going to be your contract, that you include the legal terms and conditions, including those assumptions and exclusions I talked about before, in your contract. You should have a contract always ready to go, because you would be surprised sometimes where you'll engage with a contractor or an owner and they say, well, give me your form of contract, give me your agreement. Um, and if you don't have one ready, then you look a little less sophisticated. So you want to make sure that you always have a form of agreement ready to go that has all of those things in it. Now, there is one exception to this rule where sometimes no agreement is better than a one-sided agreement. And I'll explain this with a story. We had a client who's an electrician who started a job based on a handshake, provided a quote. That quote was never executed. They started the work month 1, month 2, month 3. It comes time now to get funded for month 3. And the contractor says to our subcontractor electrician client, we are not going to pay you until you sign our contract. And his response was, well, I don't agree. I've already given you all of my proposed changes. And they say, well, we don't agree to those changes. So if you don't sign our contract without any changes, and obviously it was a very one-sided general contractor agreement, if you don't sign our contract without any changes, then we're not going to pay you. He felt trapped, and he unfortunately made the mistake of signing that contract and continuing on with the job. And it turns out that the contract he signed actually at the desk in order to pick up his check at the contractor's office didn't include all of the scopes of work. I should say it the other way around. It included more work than what he bid on. But because he didn't review it, because he was forced to sign on the spot, he committed to provide more than what he bid on. Plus, it had all these terms and conditions which he didn't agree to. Fast forward a few more months, the job goes sideways, and now he's in a dispute with the contractor. Unfortunately, the agreement that's going to control this relationship is the one he didn't want to sign, but in fact did. So, hindsight being 2020, what should you do? In that situation, you should not sign the agreement. The advice to him, had he called us when this occurred, would have been, don't sign the agreement. If they're not going to pay you, then your agreement is effectively a handshake, which has terms that are better for you than what is in the contractor's contract. And if you need to, you can lien. That's another thing folks don't understand, is that even if you don't have a written agreement, if you've done work on a piece of property, you still have lien rights. So the client could have walked off the job, put a lien on the project for all of the work in place. And, it's not an ideal situation. We may have still had to fight over the lien, but actually his situation was significantly worse because of the terms and conditions he signed. So that's an example of one situation in which having no agreement is better than the one-sided agreement that someone may force you to sign. The number 4 mistake we see is folks not understanding the pay when paid provision. Now, this is a very common contract provision. It shifts the risk of non-payment from one party to another. So, as an example, with this provision in place, between a contractor and a subcontractor, if the owner doesn't pay the contractor doesn't have to pay the subcontractor. What do these provisions look like? I'm going to show you one in a minute, but generally speaking, they are these payment terms, and they use the words condition precedent or contingent upon. And the Florida courts have made it very clear that if you use those magic words, condition precedent or contingent upon, that pay when paid provision is going to be enforceable. So what does that mean? That means if you're a subcontractor working for a GC and they have this provision in their contract, then if they are not paid by the owner, they don't have to pay you. This means even if you've done your work, you're on time, no defects, you've paid all the materials, all the labor, the risk of non-payment falls on you, not the contractor. So you have to be very careful about these types of provisions. So let me show you what one looks like. So this is a simple example. Final payment shall be made within 30 days of completion of the construction project, acceptance by the owner, and here's the magic language, as a condition precedent, receipt of final payment from the owner. So this is a valid and enforceable pay when paid provision. I will tell you, it is exceedingly rare that we find a contract that doesn't have the magic language in it. We still see it every once in a while, but we're talking once a year of all the contracts we review. It's exceedingly rare. So what can you do to deal with it? Well, obviously, if you're a general contractor, you want to make sure that provision is maintained. Most GCs are not going to strike the pay when paid provision. Sometimes, however, we have had our subcontractor clients have some success at striking the magic language, meaning the agreement, the provision stays intact, but they strike the condition precedent words. And if need be, if we have to argue that in court, the having the provision without those magic words can go a long way at making that provision unenforceable. What's more important than focusing too much on the pay when paid provision, and again, you just need to understand how it works, is having other provisions to give you some cushion because you're going to have to deal with this pay when paid provision. And that is including the right to stop work. And that goes to our fifth mistake that we see in contracts, and that is not having the right to stop work. So let me show you a sample provision. This is a provision that exists in many contracts. A subcontractor shall not be entitled to stop the work on account of a contractor's default, including non-payment, but shall proceed with the dispute resolution procedures in this agreement. What that means is if you are not getting paid, you are not getting your change orders approved, you are being asked to do things out of sequence, whatever the issue may be, your remedy is never to stop work. You always have to continue working. You can proceed with the dispute resolution process in the agreement. That typically means either a meeting of the principals, a mediation, maybe it's arbitration, which is like a private court, or litigation, which is the court that most folks know and understand. But that means that as you are trying to resolve the dispute, you're still paying your bills to your material suppliers, you are paying your labor and employees. And remember, if the owner is not paying the contractor and there's a pay when paid provision in the contract, then the contractor is not even technically in default because they don't have to pay you until the owner has paid them. So you as a subcontractor effectively are funding this project. So what can you do? You want to specifically include the right to stop working if you are not paid. So here's a sample provision. Subcontractor may slow or suspend work if any payment requests have not been paid in full within 30 calendar days from submission. Now, this is a pretty aggressive stop work provision. Typically, this will not get accepted in its current form, but again, this goes back to the idea of being willing to negotiate. So we typically see contractors revise this provision so that it's not 30 days, it's 60, 75, 90 days. The important thing is that you at some point you have the right to stop work. The other change we see contractors make with respect to this provision is they say that it's only with respect to approved payment requests. You have to be careful with that, right? Because what if it's not approved? You know, that kind of dovetails right into the pay when paid. But again, it's better to have something, some change, some right to stop work rather than no right to stop work. Mistake number 6, and this is especially prevalent right now, and that is not accounting for price escalation in your contract. Most contracts, whether it's an owner contract or a GC subcontract, specifically says the price is the price. It's never going to change. Here's a sample provision of that. The contract sum is inclusive of any and all labor, materials, and related charges, including but not limited to labor and material price escalations. Under no circumstances shall subcontractor be entitled to any additional compensation, increase in the cost of the work, or the contract sum due to increases in labor rates, commodity prices, taxes, duties, and tariffs. So what does this mean? This means that even because of COVID, even because of material shortages, you are not going to be able to go back to the contractor and say, or the owner, and say, I need more money because I accounted for steel or plywood or insulation at X dollars, and now it is 50% more, 100% more, 300% more. A contract provision like this is going to tie you to no price escalation. Sometimes clients come to us and say, well, yes, I know, but what about the force majeure clause? Number one, even if you have a provision in your contract that is titled force majeure, know that force majeure by itself doesn't mean anything. You have to look at the provision. And what we typically see in these one-sided contracts is that the force majeure provision is limited to things outside of cost escalation. So strikes, acts of God. So it's not really going to cover price escalation. At the same time, we typically see these contracts specifically include a no price escalation provision like the one I'm showing you here. When you put that together, legally, you have next to no right to ask for more money. So how do you deal with it? You need to change that provision or include an addendum, and we'll talk about how to make all of these changes in a minute, to have the right to increase the cost. So here's an example of such a provision: where the delivery of materials is delayed or quantities are limited as a result of shortages, rationing, or unavailability, subcontractor shall not be liable or responsible for any delays or damages caused thereby. When this occurs, subcontractor shall propose substitute or alternate means of acquiring said materials, and contractor and subcontractor shall negotiate an equitable price adjustment to the contract. When the cost of labor or material exceeds 25% more than the documentable price originally carried by subcontractor, then subcontractor shall notice contractor in writing of such change, and the parties shall come to a mutual agreement on a new equitable price adjustment to the contract. So again, this provision and all of the provisions that I'm giving you as potential alternatives are not likely to be accepted as drafted. You need to know that going in. The key is that it starts a conversation. You know, the contractor or owner has given you a contract, and that contract is in their favor. You're going to go back with changes that you want on some of the provisions to make the playing field a little more level. And then you have to be willing to have this back and forth as you negotiate each of these terms. What we are seeing with respect to price escalation is that most contractors are telling their subcontractors that, look, I don't have the right to ask for more money. If the owner agrees to pay more money, I'm happy to pay you more money. But if the owner doesn't agree, then I can't pay you more money. And most owners are saying, well, my pro forma, my loan is based on the fixed price that you gave me, so I can't agree to increase. The only time that we have seen price escalation work through the system is where the cost and disruption to the project of someone walking off the job because they can no longer absorb those price increases, they being a sub, um, is so traumatic to the project that it is cheaper to pay them some more money, maybe not all the money they're asking for, but some more money in order to keep them. So, for example, if the price escalation of lumber is such that the roofer, for example, comes and says, I can't do this job for this price anymore. If you don't agree, I'm going to have to walk. And yeah, maybe you'll sue me, but I just can't, I can't lose this much money on this job. I want $250,000. And the owner and or contractor say to themselves, well, geez, if this roofer walks off the job, it's going to cost me $500,000 to find another roofer. And if we sue him to get the money, he's going to be out of business. So what are we going to get? We're going to get nothing. So what can we do? So what if we give this roofer maybe not 250, maybe we'll give him $100,000 more. That's more than we want to pay. It's less than he wants to get, and we can avoid this mess. So we're seeing that play out as parties negotiate based on the two things: the fear of someone leaving the job, number one, and number two, the likelihood that the actual cost, if they had to replace a sub, would be significantly higher. So it's better to pay a little bit now and avoid that problem in the future. Mistake number 7, not having notice and opportunity to cure. If something goes wrong in your contract, you want to make sure that you have the right to fix it before you are supplemented or back charged, or even worse, terminated. So let's take a look at a provision that exists in most contracts. Contractor shall be entitled upon 1 calendar day written notice to subcontractor to correct any deficient work or materials and deduct the cost thereof from any money then due or that may thereafter become due to subcontractor under this agreement, or at the election of contractor, terminate the employment of subcontractor under this agreement. This is pretty severe. This says that the contractor can back charge you or terminate you with 1 calendar day notice. Think about that. They send you a notice on Friday, and if you don't fix it by the end of the day on Saturday, they can fire you. That's not reasonable. No one can react that quickly. So what do you want to do? You want to change that provision so that you actually have some meaningful rights in order to fix the problem. So here's a sample provision that would give you more rights. Contractor shall provide subcontractor 10 calendar days, detailed written notice to cure any performance issue or delay or claim, or before any payments are delayed or held back, or any amounts are chargeable to subcontractor. So before anything can happen to the sub, they need to be given 10 calendar days notice. Now, obviously, you're going to want to, the likelihood is there's going to be some negotiation between 1 day and 10 days. Maybe you land at 5, maybe you land at 7. But what's absolutely critical is that you get as much time as you can, number one. Number two, that notice be in writing. You'll notice sometimes that the notice to you from the contractor or the owner doesn't say it has to be in writing. You want to make sure that that notice is in writing, and you want it to be detailed. You want it to explain exactly what's wrong so that you can try to fix it. Keep that in mind. This is one of the more significant changes I would suggest, and more helpful changes that you can make. Slowing down the termination or back charge process is really important, and adding a layer of written notice is critical. The 8th mistake we see, not having control over your schedule. You have bid this project based on how you intend to attack it. We're going to have folks show up on the first floor, second floor, then the third floors we're going to skip for these reasons. We're going to go to 4, 5, and 6, and then we're going to come back. And this is how we're going to attack the problem based on when materials are available, when our men are most available, what's happening on the job. So you have to be careful that a contractor can take over from you the control of your schedule. So here's an example of such a provision. Subcontractor shall accelerate, decelerate, stop, demobilize, and remobilize its men and materials and the men and materials under its control to maintain the proper schedule as amended by the owner, prime contractor, or contractor, all of which shall be included in the agreement price. So they're saying we can speed you up, we can slow you down, we can move you around on the project as we see fit. You cannot ask for any more money because you've accounted for all of that in your contract price. Here's a sample provision to try to push that back. Any and all changes in the schedule or delays caused by those other than subcontractor shall be the subject of a change order entitling subcontractor to additional time and compensation. Again, not that they can't control it, but you should be entitled to more time or more money to the extent that that change or delay or impact has some monetary effect on you, and most likely it will. If you don't include provisions like this in your contract, the problem you're going to have is that as these changes to the construction schedule occur, you are not going to have a very good legal ground to stand on in order to try to collect for these impacts. The ninth mistake we see folks make is they wait way too long to collect on the money that they may be owed. We find that contractors, subcontractors, typically wait far in excess of what we would recommend before they start the collection process. So let's go over some of the basics so everyone understands those timeframes. You only have 90 calendar days to record a lien or to serve a bond claim based on your last date of work. Let's break this sentence down a little bit so you understand. It's 90 calendar days. It includes all weekends and legal holidays in the 90 days. The only time you get more than 90 days is if the 90th day, the 90th calendar day, falls on a weekend or legal holiday where the courts are closed. So if the 90th day is a Saturday, it goes to Sunday, it goes to Monday. If Monday is a holiday, then it'll go to Tuesday. So maybe you'll get 91, 92, maybe even 93 days. But that is the maximum amount of time that you need, that you have in order to record a lien or to timely serve your notice of non-payment on the surety. Also know that last work does not include punch list, corrective, or warranty work. It's last work that entitles you to be paid under your contract. And it does include change order work, but ideally it's a change that you have in writing. The best case scenario is you have a fully executed change order, but barring that, some email or written confirmation of this additional work that you have to do, that would likely extend the 90 days or that will extend when your last date of work is. One of the things that we have seen lately is that because of COVID, the clerk's office in every jurisdiction is closed. Only now are they starting to open up to take people in line to the and accept documents at the clerk's office. So otherwise you have to record it electronically, and it's not like ordering from Amazon where you'll get something right away. The clerk, for example, now in Miami-Dade County is taking 7 business days to record liens. That means if I submit it today, it's going to take 7 full business days before the lien could be recorded. That number fluctuates. Sometimes it's 3 days, sometimes it's 5 days. know that the day that it is counted as recorded is the day that it is actually recorded by the clerk, not the day you submit it in the queue. So we've had clients, unfortunately, come to us on day 88 and ask us to prepare a lien. We prepare the lien and tell them this is probably not going to get recorded on time, and there's really not much else we can do. We submit it for recording, and it gets recorded on day 94. Because the clerk just took that long to record it. So I would suggest that you don't wait until the 80th day, 85th day, 88th day to start the lien process. You should start thinking about and putting together the information to lien at about day 60 from your last date of work. That'll give you plenty of time to get the paperwork together, to prepare the lien yourself, have your notice service do it, have a lawyer do it, submit it to recording, mail it out, and no one's under the gun to make sure that it gets timely recorded. After you record your lien, our suggestion is that you use your own internal collection processes for about another 30 or 60 days to get paid. So what does that mean? That means making phone calls, sending emails. If you're a supplier, you're going to call and email your customer. If you're a sub, you're going to call the contractor. If you're the contractor, you're going to be calling and emailing the owner. Go and show up to their office to pick up a check. Whatever it is you need to do to be the squeaky wheel, that's what is likely going to get you paid on your own and as quickly as possible. After that, unless you have a specific business reason to wait, I would suggest to you that that your case is not going to get better. It's only likely going to get worse to wait to collect after that. We have clients come to us and they're owed, pick a number, 10, 20, 50, $100,000. And the debt actually is almost a year old. They may have liened, but they've been waiting and waiting and waiting. And what we find sometimes is the project manager is no longer around. The records haven't been maintained. Maybe they're lost. Someone who had text messages that were important is no longer there, or they got a new phone and they all disappeared. Time has a way of eroding people's memories, causes documents to be lost or misplaced. People move on, and it makes the case harder to prosecute. So I would suggest to you that after about 60 days, after you have recorded your lien and you've tried to do your own collection, if that doesn't work, then that's when you need to call either your collection agency or a construction lawyer to start the collection process for you more formally, which would likely include a formal demand letter and maybe even a lawsuit. But I would strongly urge you not to wait much more than about 2 months after you've recorded your lien if you haven't already been paid or received partial payments. The 10th mistake we see clients make is not knowing how to make these changes. So I went through lots of changes that I would recommend that you make in your contract. So how do you do it? Like functionally, how do you get these changes that I've proposed into the contract? So there's a couple of ways to do it. There's nothing wrong with marking things up by hand or typing them up on top of maybe you get a document via Adobe Acrobat and you can type right on it. That's okay. We typically see that contractors and owners don't like it when you physically mark up their contract. What they prefer is an addendum. That is a separate document that is attached to the contract, and it's titled addendum, and it says, this addendum shall modify and supersede any and all provisions contained in the agreement and all exhibits referenced therein between contractor and subcontractor for the project. What does that mean? That means that this addendum now is going to control over conflicting or different or blank terms in the contract. So you're not going to go through every change. You could in the addendum say strike paragraph 6.4, but what I've given you are additional paragraphs where you could add them to the addendum. And the intent is that when the contract says you have 1 day notice and you've now added an addendum that says you have 10 days notice, that 10-day notice addendum provision will control over the 1 day notice provision that's in the contract. Again, you could list all the changed, deleted, and new provisions in the addendum. It's going to be signed by all the parties, and also know that if you have scope, price, schedule, and means and methods changes, you can add them to the same addendum that you are going to then propose to the other side. So what we typically see is the subcontractor client of ours, for example, or contractor client gets the addendum, gets the contract, either has us create the addendum or they create an addendum themselves, and then they send the addendum back. What we're also seeing is folks using electronic signatures, or electronic document controls like DocuSign or Right Signature. And the way that would work would be that you would negotiate back and forth the addendum, you would agree on it, and then when it comes time to sign the agreement, even if it is in DocuSign, you're going to verify that that's the agreement that you've agreed to and that the addendum is part of it. So you're going to sign both the contract and the addendum. So with that, we've covered the 10 mistakes we see folks make. I see we have a few questions here. I'm going to get to those in a minute. Know that we have a podcast that comes out every week. You can go to the lienzonepodcast.com and subscribe to our podcast. They're typically pretty short, 10 to 15 minutes. Occasionally we have longer ones. Sometimes we have interviews, and we cover liens, bonds, contracts, and other construction issues that are relevant to you. Before we talk about the next Lunch and Learn, let me go through some of these questions. Do you recommend trying to make changes with an owner? Would it make us look bad? No, I think making changes with any counterparty is deemed reasonable. I don't think anyone would be offended by you making changes to their agreement. Sometimes what we see folks do is they say, well, they gave me an AIA standard contract, so that's pretty fair. That's true, but it shouldn't prevent you from making changes to the agreement to get a better deal, to clarify issues. The AIA form of agreement, and there are many others, are good. We find them as a good starting point, but by no means are they should they be the end. Also be aware that if someone hands you a document that looks like an AIA contract, they may have modified it themselves, and there may be changes to the agreement that are not properly reflected. So you may think, well, I understand the AIA contract, so I'm okay with it. I can just skim it or sign it. You actually have to read it because people can make changes to it in ways that you may not be aware of. If you have any other questions, you can go ahead and email me. I'll give you my email address here in a minute. As far as our next Lunch and Learn, August is off. Hopefully you're all taking some time off or going on vacation in August. But we start back up September 15th, live and in person with Peter Zalewski. He is going to talk about the construction industry forecast, what he is seeing in the construction market. He focuses particularly on the condo markets east of 95 in Dade, Broward, and Palm Beach County. But what we have found is that his analysis of that market is typically a strong barometer of what the market as a whole is seeing and doing. That's September 15th from 11:45 to 1 o'clock. You can sign up by sending an email to Narcy. who will add you to the list. MiamiConstructionForum.com is the website. At the live event, all you have to do is RSVP. Assuming we have room, we'll be able to have you all present. We'll provide lunch for you. It's free of charge. And hopefully you'll leave a little smarter than when you got there. Here is my contact information if you think of any questions after this presentation. Narcy is going to send everyone a copy of the PowerPoint, a link to the video of today's presentation, as well as a list of everyone that signed up so you can continue networking and reaching out to one another after the presentation. I hope everyone has a wonderful rest of the week. Thanks for participating, and I hope to see you live and in person in September. Have a great day.